All right, everyone, it is 10 a.m. on this beautiful Tuesday morning, a little bit cloudy here in Florida, but I wanted to welcome everyone here to our Made in Florida program that we have for February. Those of you who are not familiar with me, my name is Rain McGreevy and I'm with Stromer and Company, one of the main sponsors of our Made in Florida program. We want to thank you so much for joining us today for our session, which we are covering the topic of public adjusters and associations, what you need to know, where we plan to cover some of the frequently asked questions from public adjusters, as well as to help you better understand their role in community association claims. Now, before we get started, I want to introduce some of our other panelists. Richard, do you want to start and introduce yourself?
Sure. Richard DeBose, Godey DeBose and Cross Attorneys, and we also are a sponsor of MADE. And we also have with us George Keys and John Wallagora of Keys Claims, who are going to give us a lot of good information today. Guys, why don't you introduce yourselves?
Hi, everyone. I'm George Keys. I'm the president of Keys Claims, LLC, based here in Naples.
Good morning, everybody. I'm John Wallagora. I'm the Chief Operating Officer of Keys Claims Consultants, and I reside here in Naples with my wife and 4 kids.
Wow. Well, thanks for coming, guys. I really wanted this topic because I think there's a lot of myths, misunderstandings, misconceptions, confusion about what is a public adjuster, what do they do, how do they do it. And I really, first got involved, I think, with George many years ago. I had no idea what a public adjuster was, and I was totally confused. And I think a lot of people kind of feel the same, but due to the recent Irma issues and other issues, I think they've become much more widespread, at least in my sphere of knowledge, but there's a lot I need to learn. So I guess I'd like to start off with either one of you gentlemen. What exactly is a public adjuster? What is it?
Richard, this is George. I'm happy to answer that. Basically, a public adjuster is a licensed profession in the state of Florida and almost all the rest of the states, whereas a public adjuster can only act on behalf of an individual or an insured, such as an association or an individual homeowner. It serves the same role as the adjuster for the insurance company, because the adjuster for the insurance company represents only that insurance company. If it's an independent adjuster, that independent adjuster can represent multiple insurance companies, but they cannot legally represent any individual policy holders. That profession is left to either public adjusters or attorneys such as yourself.
Okay. And how long have you been doing this type of work, George?
Well, you asked me a question that's going to show off my age, but I'm really only 25, so that's a disclaimer before I tell you that this is my 43rd year of working both for and against insurance companies. My background is I was trained by one of the world's largest insurers based out of London, and I used to run a 6-state area for them in the Deep South. And that's back in the days when they actually taught adjusters to pay claims instead of fighting them out. And in the late 80s, when they started trying to retrain me to be more of a money business, in other words, to turn a profit for them and not pay claims, I decided that it was time for me to go back to school and become a public adjuster and use the principles that the insurance companies taught me when they used to pay claims against them. And it's worked very well for me.
Okay. And how about you, John? How long have you been doing this?
I've been doing this since 2009. I joined Keys Claims. Our firm's been, well, George has been in the industry for, as he said, 43 years. Our firm was founded here in Naples in 2007. So this is where we work. This is where we live. This is our home.
Okay, so let's just take a hypothetical. There's a condo building, could be an HOA clubhouse. It could be any community association property. There's a hurricane, there's a fire, there's some kind of disaster. Let's take a hurricane that significantly damages the building. How does it start? What's just, I don't want to spend 30 minutes on it, but what are the basic steps from where you start, what happens, and where it ends? What can you give us kind of a roadmap?
Yeah, happy to answer that. those associations that we've represented in the past, I think would be very quick to tell you that typically what happens is within a week or sometimes 2 weeks after a storm, they will have an adjuster come out from the insurance company. And then several months later, they may get some type of offer. Typically, that offer after a hurricane is going to be minimal. It's going to be below the deductible or minuscule in an offering. What we do at that point in time is come in and actually investigate the claim, bring in the proper experts, usually on our dollar. We advance those costs to determine what's wrong with the property, if anything, and then present the claim and a proof of loss and represent them from the beginning to a final conclusion. That is paramount because without exception, every one of the cases that we've been involved got an exponential increase over what was originally offered. And that's not an anomaly, and there's a reason for that. There's a study done years ago by a consulting firm called McKinsey. Right in the very turn of when insurance companies stopped paying claims and started trying to make more money, McKinsey told Allstate that if you will start denying claims and put up a fight, only 2%. 92% of the people will always agree with the adjuster. If the adjuster says there's no damage or there's $2 in damage, 92% of the people would not argue with him or her. 2% of the remaining 8% would actually get professional help, such as yourself or a public adjuster. And the other remaining 6% would fight it out themselves. It has been documented by the state of Florida through different independent resources that the increase over what an insurance company offers in their original investigation versus what a public adjuster gets them can have an increase of an average of somewhere around 13 times what they've been offered.
Wow. Wow. So let's just take a numbers example without obviously disclosing any names. What was an example of an offer and where did it end up after you did your work and the lawyers and everybody?
We just had one a few months ago that we have a plethora of them, but the best example I can tell you is that the insurance company went out to a local waterfront free high-rise building, beautiful complex in North Naples, and came back with, after their investigation, that all of the damages were pre-existing or were wear and tear. And as such, there was no claim to be made. We represented the individuals and took them through appraisal and ended up with a $32 million award, which they paid.
Wow.
Yeah,
wow.
The association ended up with all new roofs, all new windows, all new doors, a lot of drywall work, and had all their mitigation covered for the water intrusion. The insurance company actually were so brazen that they actually said the only reason that the water came in the building from the storm was because of lack of maintenance on the windows. And
okay.
So that fell on deaf ears.
Okay. Well, let me turn to Rain here. Rain, let's say an association hits a home run and gets a $32 million award. How do they, I mean, that's probably more money than they've ever seen. How would they account for it in their year-end financials and things?
Sure. So anytime an association gets insurance proceeds, it's important for them to note that they have to recognize that as revenue. I've seen some associations where they try to offset expenses against it and try to net those things kind of together so that way it doesn't look like they got this big amount of money as revenue, but you're not misstating your financials correctly. So it must be treated as revenue. What goes hand in hand with this is when you recognize it as revenue, this may change your year-end financial reporting requirements. Just to go over those briefly, just so you keep that in mind, if your association has more than $500,000 of annual revenue, by statute, you're required to have an audit. So in the situation you got $32 million, you're going to have an audit done that year. If you have between 300 and 500, your association's required to do a review, and between 150,000 and 300,000, your association's required to do a compilation. So very, very, very important. If you're expecting some type of large insurance proceeds that are coming in, make sure you line up with what type of financial statement report that you actually have to have prepared.
Okay. And will the association have to pay any kind of different tax on that money?
All right, so that's a wonderful question. Normally, that's like the very second question that gets asked after they get all this money and they're talking to the accountant. And I do have to put a little bit of stipulation on this answer because I'm giving you an answer in the general context of things. Every association and the specific situations are slightly different. So I can't be your accountant and tell you, Rain said this is the way it works. But in the general spirit of things, if you're getting insurance proceeds to help mitigate physical damage that an association actually has, typically those types of proceeds are not taxable. If you're getting them in for pain and suffering and for all sorts of other things, then you really need to talk with your accountant who knows the specific situations, because in those types of situations, most often those items are taxable. So get with your professional on it. But if it is generally for physical damages and repairs, most of the time those things are not going to be taxable.
Okay. Well, John, let me ask you. George kind of described the process from start to finish. I know this is difficult to answer, but is there an average time from start to finish you could put on it, or every case is completely different?
That's a great question, Richard. I would say, every case is different, but typically on these large association claims, it can take between 9 and 12 months, but a lot depends on the carrier, the amount of claims in the area, what the carrier has on their plate. So there are outliers in all claims, but really it's going to come down to each individual claim and the parameters regarding that. But 9 to 12 months is a typical time.
Okay. Well, in addition to associations, who can hire a public adjuster? It's not just condo and HOAs. Can individuals hire them for their own house fire for their home?
Absolutely. So any policyholder, including a homeowner, a condo unit owner who has their own policy, a business owner who has a business policy, anybody with a policy can hire a public adjuster to represent them through the process.
And Richard, one of the most intriguing things about that question and John's answer is that we also have the liberty of and the honor of representing a lot of the adjusters and their attorneys when their own claims don't get paid.
Yeah,
which I find amusing.
Right. Well, that leads me into my next question, which I know the answer to, but whenever Rain and I go to lots of seminars and we put on a lot and we speak at them a lot, and there's always an insurance agent involved. Okay. And if the word public adjuster comes up, it's, I guess I understand, but why don't you explain? I mean, people, the adjusters or the insurance companies obviously don't like you because you fight against them, but can you give any background on, why it's such a negative from some people's point of view, other than they lose money?
I'll be glad to. Some agents actually bring their insureds to us after a loss, saying, we want you to make sure that our insureds are well protected. That's the kind of agent that everyone wants. Okay. And when the agent himself has a claim, oftentimes they give us a call. But other than that, the reason why they do not want us involved is this. A lot of insurance contracts which allows an independent agent to sell policies for a carrier. Typically, their contract has a clause in it that's called a loss ratio bonus. And what that means is basically this. The less amount of dollars that's expended on that agent's books for claims, the higher their bonus is at the end of the year. So naturally, if they can downplay a claim and not have a claim submitted or have a public adjuster or attorney involved in a hurricane claim, say, or a fire, the more money the less money that's paid out, the more their bonus is. That's not always a fact, but that certainly is a prevalent practice in the insurance profession.
Okay, well, that leads me to my next question. How do you guys get paid typically?
We get paid if we're acting as a public adjuster. Our fees are contingent and it's contingent with a generally usually a 10 or 15% fee, and we advance costs so that we do not ask the insureds for any payment for either our fees or the expert's cost until we have an outcome for them.
Okay, so it's kind of like, if you don't get them more money, then you don't get paid. So there's really not much risk on the association side, it seems to me.
We try to leave all associations with the full understanding that we're a team, and that as a team, we're either going to profit or we're going to lose together. And I don't like to lose. And so I'm very careful which cases I pick. And if I tell someone that I think we can win a case, we're pretty effective at getting that done.
Okay, and you mentioned it. Maybe, John, who are the people that help you, come up with this? I mean, you guys aren't engineers, I don't think, but who helps you? Who's part of this team?
Well, our team consists of, it could be a specialized contractor who gives us bids that are specific to a condo association. It could be an engineer. It could be a roof consultant. We're going to bring in all the experts that are needed in order to back the claim up, and for them to tell us what they see and how then we can address that in our estimates and what we submit to the insurance company.
Okay. And I know there were some new laws that were passed last year, I believe, that had some effect on public adjusting. Can you expound on any of those?
Sure. Yeah, there were two major bills last year: Senate Bill 76 and Senate Bill 1598. And these affected both public adjusters and policyholders. And I think the most important one was Senate Bill 76, which reduced the amount of time to file an insurance claim or any claim with the carrier, and it is now 2 years. So a little background on this: when Hurricane Wilma hit in 2005, policyholders had 5 years to file a claim, or 2010. In 2011, Senate Bill 408 was passed, and that reduced that time down to 3 years. So that's what we had when Hurricane Irma hit. We had until 2020 to file, for policyholders to file claims. Now, after Irma, it's been reduced yet again to this 2 years. So it's very important for policyholders to know about these deadlines, because these changes keep happening, and we're on top of it, and we can answer all those questions along with our legal counsel. Senate Bill 1598, one of the provisions in there it's good for homeowners and condo unit owners to know about, is that if they hire a public adjuster must provide an estimate to them within 60 days. This is new language that was passed last year that went into effect. One other major part of Senate Bill 1598 was regarding unlicensed activity. It's been a big deal out there with contractors and other folks basically practicing public adjusting and or law. Only public adjusters or attorneys can negotiate with the insurance company. So now it's a third-degree felony for anybody who knowingly aids or abets in this unlicensed activity. So the state's been trying to do something about this for a long time. Now there's some real teeth into this law to stop contractors and other folks from practicing. And also it limits their solicitations, because everybody's gotten in the mail these cards from roofers telling them about how they can get a free roof for them. So all that is now stopped because of these new laws that went into effect.
Yeah, I can tell you that I frequently saw during the Irma window there, using the assignment of benefits clauses, the roofer was basically negotiating with the insurance company. And I felt, well, that's what public adjusters do. And so I think that law was well founded, because there was a lot of that going on where the roofer would just say, sign this one-page document and we'll take care of everything. And then we would make money as lawyers, because the board would come to us after they signed it and say, well, the guy hasn't shown up, and it was a mess, this assignment of benefits. I know they changed that law several years ago to kind of crack down on that, but they were clearly adjusting the claims in my mind, for sure.
No doubt about that, Richard. One of the other things I'd like to say to the panel is this: that law also opens up the doors for anyone trying to meet with an adjuster and negotiate a claim, such as a property manager or someone other than an individually insured person trying to adjust their own claim, which is allowable. You really need to seek counsel before you try to do that and know what to say or what not to say to an adjuster, because if you start negotiating a claim as a property manager when you're not a licensed attorney or a public adjuster, it could have some serious ramifications.
Yeah, and property managers are our friends in my industry, but I did see some that when they saw these large awards would put in a fee, a percentage fee. Well, if we help you get this insurance money, we're going to get X percentage of it. That seemed to me like kind of getting a fee for adjusting as well. So we try to look for those sometimes.
Yeah. Yeah, one of the things that I've seen in that regard that I think that property managers should have that fee on is simply to manage the repairs after the claim is settled. So for instance, if something that you guys are involved in and you settle a claim, well, there's really very little that the association, unless they have a very astute president or board, can do to try to manage and getting all the bids and supervising all that. Whereas if the property manager does that, he will need to be compensated for that. And that's what that 2% typically is for.
Yeah, and we certainly recognize there's a lot of work that goes into the property manager that doesn't regularly, have this kind of work, but there's a big disaster that's going to take up your time. And that, I think it's absolutely reasonable that they get extra compensation for that. Let me ask you, what can the association or the individual do right after the disaster, before they've even contacted you to help you? Pictures, video, should there some actions they be taking that will assist in the claims process if they take them immediately or before and after?
Well, really what I like to see, and I do have a lot of clients that, as a matter of practice, because we've represented them and represented the associations in previous storms, it's very helpful if the board will go around or send out a memorandum to all the unit owners or the tenants and ask if anyone videoed or photographed either during the hurricane, before the hurricane, or after the hurricane, because those videos or photographs can be hugely helpful when we actually conduct the hearing and we're presenting these damages to a retired judge who needs to make a decision as to the value of the claim. So if that board can, there's a couple different other things, but if they can check to see if anyone has taken photographs or videos, that's very helpful. But all of the associations, and whether it's a homeowner association, condo association, or even someone's own personal residence, you are dollars ahead if you will simply allow someone, my firm or any other firm, to come out and do a pre-loss survey. And what that basically means is that if my firm were to come out and do a pre-loss survey of your association and say that, okay, we've certified that the windows are not damaged, that the roof is insurable, it's not damaged, and that there are no pre-existing damages to that association as of that date, that goes a long way to defeating any insurance company's assertions in the future and defenses about all of these damages pre-exist, because they know us well enough to know if it's there, we're going to find it, we would opine on it and pursue the claim. So if they have something from us that says, or any other firm that says there's no damages here as of this date, logic would tell you if something happens after that, that association is well suited then to prosecute their claim and get a successful return. Okay,
and is there a charge for this pre-event kind of inventory?
No, what we do is we'll get a pre-loss agreement signed typically and renew it each year or every 2-3 years, depending on the association. And then it's basically all it says is that if a loss happens, they're going to retain us to represent them in the future.
Okay. Rain, do we have any questions from the audience?
Yes, there's a questions that came in. The first one, I think it's for George and John. Are your fees / percentage taken from the amount of the insurance company will pay out anyways?
It depends. If the insurance company has made a pittance of an offer, and let's say that if you have $1 million claim and they pay you 100, we have to, once we get involved, there's two different ways we'll work that. One is a larger percentage of just the increase, which is typically 15% of just that increase, or 10% of the entire amount, whichever is less.
Okay, okay.
And we don't charge a fee on the deductible either.
That's right. So it's a net payout.
It's a
So
net
if someone has one of those massive deductibles, we recover their damages in excess of that deductible without a fee, because our fees based on the net payout.
Okay.
All right, I'm going to do my best to hopefully explain this other question that came in. It says hurricane, wind versus flood / surge damage dispute. Who will pay the damages if from both wind and storm surge? So I don't know if you guys will know that answer. I think they're trying to identify whether wind insurance, I guess it would apply, whether it's wind or flood from storm surge.
It could be both, or it could be if Frontline's policy does not have an anti-concurrent causation clause within it. Those are all things that someone like Richard or myself needs to look at to determine. And if it does not have an anti-concurrent causation exclusion in it, meaning that damages are excluded for if flood hits it for any reason, then those are things that we need to look at the policy to determine. But you could have flood coverage, you could have windstorm coverage, or you could have a combination.
Yeah, our MAID seminar last month in January, we had an insurance agent and he spent the entire hour on exclusions, all the types of exclusions that are buried in your policy when you're, and I'm not here to bash insurance agents. But you have seen the movie, I think it was a John Grisham book, where the first 3 rules in the insurance adjuster's book are deny, deny, deny. Or deny, delay, deny, or whatever you want. I mean, they made a movie about it. So it feels like that's got some truth to it, obviously. But the exclusions were amazing to me. How many things you feel like they say, here's your premium, you pay, you're in good hands, we got everything covered. And then from personal experience and helping clients, I mean, it's the fine print in the exclusions that, oh, well, that's not covered. The one I love the most is wind-driven rain, as opposed to just rain coming in. I just conceptually, I think, how do you have the nerve to make this up? There was a hurricane. The water came in because of the hurricane. Why are you saying, but that was wind-driven rain, so it's not counted? I just find that amazing to me that they have the nerve to do that.
Well, you know, Richard, that is one of my pet peeves, and you hit a good analogy there, and you're in good hands. You're only in good hands until you have a claim and all you get's a finger. So the way that you have to look at that wind-blown rain exclusion or limitation is simply this. You hit it right on the head. You can't have a hurricane without wind. So the wind-driven rain provision should apply to non-hurricane events.
Okay.
To keep you, if you look at that, most of those policies that have a provision for wind-driven rain, they have a very large hurricane deductible. So to keep one from breaching that deductible, having to breach that deductible, they have a different coverage called wind-blown rain, because under a commercial policy, unless there's an opening caused by the wind, interior water damage is not covered. So they give you back supposedly this wind-driven rain provision coverage. Basically what it's meant to do is if you have a severe thunderstorm that's not a named storm, then you're still under your all peril deductible and you can exercise coverage there. That's the only place that coverage is meant to apply. It's not meant to apply from hurricanes, despite the fact that these adjusters continually try to do it.
Okay, that's great. More questions, Rain?
Yes.
Rain, appropriately, her name is
I know,
Rain.
of course. Wind-driven rain, of course, I'm here. Yep. So they were also asking, can you give your thoughts on the importance of getting a public adjuster quickly in the case of something like assessing damage caused by faulty plumbing?
John, you want that?
That's a great question. It is important to bring us in a public adjuster, us or anyone, immediately after you have a loss, so we can document these damages, and also so we can meet with the insurance company, meet with their adjuster, and point things out to them before they, go back and put together their estimate. We're there pointing things out, pointing coverages out, and that generally results in a better outcome.
Perfect.
Okay.
I have another question that came in, and this one's for me. The question is, what are the tax implications, if any, if there was a balance? For example, $1 million left over of a $32 million claim that was used towards for damages and repairs. So the first thing I would probably say is to take another look at your financial statements. Likely there are some other kind of miscellaneous expenses that you've actually incurred. Might not be specifically from the roof, but if you've had to have an auditor come in and now audit your books, and had to maybe had an increase in fee because of all of the different activities, well, there's some additional fee that's really eating away at that. Likely you're also going to have management fees. Maybe there's an increase in management fees and those other miscellaneous things. Legal fees from your attorney having to do with consulting going back and forth. So many times your association will be able to start dwindling down that number, hopefully down to about a net of 0, so you don't have to worry about taxes. But again, just like I said earlier, it's really, really, really important that you consult with your accountant who knows your specific association and knows the specific circumstances to avoid and hopefully minimize any type of taxes due. Another question that came in, how does the role change, kind of talking to George and John, when the insurance company goes insolvent?
Well, that's a great question, because Richard can attest to the fact that there have been some insolvencies amongst the carriers. The latest of which was American Capital. They for immediately after the storm refused to pay claims. They had come up with the most ridiculous questions of reasons not to pay the claim that you've ever heard. I early on suspected that they had no money, and it turned out they did not have any money. Certainly not the amount that they needed to pay the claims. Luckily, when you have an admitted carrier such as AmCap, or most of the Florida admitted carriers that are licensed to do business in the state of Florida, they're backed by the Florida Insurance Guarantee Association, which is a state-run pool. If you'll notice that when you get your premium notice for your homeowners policies, and those property managers that are managing associations for the association's policies, you'll see a little additional charge on there for the FIGA participation. What that is that money goes into a pool that's administered by the state, and the state has its own claims department that then handles those claims after the process is completed with regard to the liquidation of that company. So
Let me ask you, I mean, are you just trading, now you're in the hands of the government? That isn't always the best thing. I mean, how difficult is that fight now that you're dealing with a whole set of new adjusters?
Well, anytime you have a pool of money, whereas with AmCap, they had no money, but FIGA does have money. And most of the people at FIGA at least have a brain that you can work with to try to get money out of them, to let them know this is what you need to do. This is what you have to do under the law. Then they're getting these claims paid. And I've had those claims paid without exception. Whereas when you fight for years against a carrier that truly is just trying to battle insolvency, you may never get that claim paid if they're teeter-tottering on insolvency until it gets into FIGA. So if a company is going to go or borderline insolvent, it's best that they do it sooner than later, simply so the state can liquidate that company and get these claims paid for people.
Okay, well, let me ask you a question that may sound a little softball or self-serving, but I know it's true from lawyers' side that certain lawyers and law firms have reputations that we're going to take this to the wall, take it to the bank, take it to the mat, and we're not going to roll over when you throw a few dollars at us, as long as it's in the client's best interest. Whereas other lawyers, maybe the insurance companies know, well, they write letters, but if we offer a little more money, they'll take it. Is that true in your industry where if you have built a reputation over the years that maybe the insurance company won't play as many games because they know the games are not going to work based on their experience with you and others like you, other experienced PAs?
Well, one of the, I'm going to try to answer that without blowing my own horn, my firm's own horn, and is simply this. When insurance companies get a letter of rep from my firm, they know they're going to be held to the letter of the policy and the law, and that we're going to be uber aggressive. Now, typically what that does is a couple different things. It usually pins to a different class of adjuster. It usually goes, he usually has 2 or 3 lawyers behind him. And I know because I get to see this in discovery when we get these files where the lawyer's guiding the adjuster's guiding the lawyer as soon as they get our letter. I can tell you that AMCAP, we have in one of the discovery files that we have, their adjuster made a mistake and sent us a letter where she wrote her supervisor and said, please do not put me on any more files where Keys Claims is on this file because I'm not competent. And
wow.
I'm happy to share that with everyone because that adjuster now is a public adjuster. Since AMCAP went insolvent, but I take that letter as a badge of honor because we do work hard to make sure that we sleep well at night.
Yeah. Is that a normal transition where you might like lawyers that are in the state attorney's office prosecuting crimes will often cut their teeth and then move to private practice and become defense attorneys defending criminal activity because they know all the ins and outs of the prosecution side. So is it a normal transition to have adjusters that work for the insurance companies move into your side of the industry?
In the day back when I transitioned, it was very rare. Now you see more of it, but the adjusters today, in all fairness, they've not trained the way we were trained. They're trained to play the game that they've been playing now. So when those guys make the jump to being a public adjuster, a lot of those fail to do it because they don't understand how to read the policy or apply the law to a policy. Because they're not trained to, because ignorance is bliss to an insurance company, in all honesty, because if you keep your adjusters ignorant, they don't pay claims. So if you have an individual that's trained by an insurance company to read a policy, apply the law, pay a claim, his whole different mentality his mentality is totally different than someone is taught never to pay a claim. And so the transition is light years apart when one tries to go to be a PA versus the other trying to go to PA. And I think that when insurance companies trained me and I began working on the other side in 1992, it was a learning experience for me, but I knew how to read policies unlike a lot of the adjusters I was going against, and it helped me immensely. And a lot of my inside senior people are all company ex-adjusters. Do
you foresee in the future that there's going to be any kind of insurance industry reform that within their self-reform where it won't have the reputation and feeling that it's always deny, and maybe get a little bit back to paying claims? I mean, there's got to be a break even where it's not worth it anymore to deny these claims because we're going to spend thousands defending ourselves and still have to pay a bunch of money. So make a legitimate payout offer up front. Is there any movement towards that, or it's just not the business model anymore?
Let me tell you, I'm going to answer that in a roundabout way. We recently, a few years ago, completed a stint of duty in New Zealand. Whereas when you were talking earlier about the agent that spoke for an hour on exclusions, where in New Zealand and Australia and England and other parts of Europe, their policy is only 4 or 5 pages thick. Our policies can be 400 or 500 pages thick, but it's all exclusions.
Yeah.
So the trend is that in New Zealand and other places like that used to have that limited exclusionary language, the trend is that now they're starting to follow our pattern, our insurance industry's pattern of not paying the claim. So they're adding all these exclusions to them. So instead of delay, I see delay, deny, defend. And this is money, and money typically only ever does one thing. If the more people get, the more they want. And that applies to the insurance industry. My professional opinion is, and I'm prohibited against speaking negatively against insurance company, but I will speak positive. I will tell the truth is that I don't think it will ever change. Not in my lifetime, anyway.
Okay. Rain, do we have some more questions?
Oh yeah, we do have quite a few. Here was an interesting one that I saw. It said, can the state of Florida Insurance Commissioner help a condominium unit owner if the association's insurers doesn't want to pay by alleging that the board did not advise them of the issue? Or could a public adjuster help a unit owner better than the insurance commissioner against the association's insurer?
That may be a third-party liability issue, and I would recommend that individual keep from paying multiple fees. Hire a lawyer that is well-suited and understanding of condominium law and 718-111 statute to understand the duties and what should have been covered under the unit owner's responsibility versus the condo unit, the condo owners, the unit owners, the unit owner's responsibility versus the condo's responsibility. And there are a lot of lawyers out there that do that.
Yeah, there's that's one of the most common occurrences, the relatively small water leak from above to below, and the interplay of the documents in the statute is very complex. I wrote a memo called the 5 most common questions about the water leak from above to below scenario, just for condominiums. And if anybody wants to email me, I'll send it to you. It kind of explains, because even people that do this all the time, insurance agents and dry out companies, they don't understand the dynamic of when it's covered by the association and when it's not, and what's a casualty loss and what's it's not. So I think the memo kind of puts it in plain language, and my clients have found it to be to get their head around this whole concept is easy. More questions, Rain?
Yep, another question that came in. This is kind of referring to kind of like that pre-assessment before some type of damage. Do you check things more than just the buildings? Meaning, do you kind of look into, stormwater management system, or is it strictly buildings?
No, it'd be strictly building. And the reason being, the stormwater management system would not be covered under the first party policy anyway. That would be unless it's a flood issue. And so the inspection, the pre-loss inspection that we're speaking of would be to document if there's anything wrong with the building from a structural perspective prior to a future event.
Okay, another question. What would you recommend to do if the insurance company wants to go to mediation versus invoking the appraisal of the condo association?
I got to tell you, I think mediation is an absolute waste of time. And you need a decision maker. And the only reason the insurance company wants to go to mediation instead of appraisal is because they know if that individual insured hires a competent appraiser, that insurance company is going to pay out a whole lot more in appraisal than they ever will in mediation.
Why don't you explain a little bit more the process? We get all the way up to they've made the offer, you've hired the public adjuster. Where does it go from there? I know you can go 2 different tracks you kind of referred to. Why don't you finish that chronology?
Thank you, Richard. And I'll try to go through some scenarios that we've had experience with your firm on, whereas we were brought on as a public adjuster. And basically what happens is we put together the claim as a public adjuster, you analyze, you bring in all the experts, you calculate all the damages, you do all the investigation, and then it accumulates in a proof of loss. And that proof of loss itself is filed with the insurance company. The insurance company typically will then deny that proof, saying it's either inflated, the damages are caused by wear and tear, for 1,000 different reasons, not pay your claim. Well, in these policies, almost without exception, is an alternative dispute resolution called appraisal. And appraisal is what I specialize in and what I go all over the world doing. it basically is like a binding arbitration, whereas you appoint your appraiser. The insurance company has to appoint their appraiser. It cannot be the adjuster. And then those two individuals agree to a neutral. Could be a retired judge, maybe a lawyer, could be an engineer, could be an adjuster. And they actually hold a hearing to present the evidence, cross-examine each other's witnesses, experts, and then out of that comes an award, if signed by any two of those three participants, is binding on you as the insured and binding on the carrier. And they have to pay that. And that is truly the biggest benefit that you have in any policy. Some of these policies, instead of an appraisal provision, have an arbitration provision. That's a much longer process, but it's a process that works also. It's not as favorable as the appraisal process. So before you renew your policies, one of the first questions you need to ask is if it has an appraisal provision in it. And if not, then quote me a policy that does.
Okay, let me, the $1 million question. We used to get this all the time back when we would do a lot of collections. We would explain the entire collection process to collect delinquent assessments. This is during the mortgage meltdown, blah, blah, blah. We'd explain all the nuances. And the only thing at the end of all that half hour of explanation is, well, when are we going to get our money? Okay, they didn't care about anything except when are we going to get our money, which is understandable. But it's, you know, so when does so you get this award, when does the client typically get the payout? Is there a time frame?
Well, the policy dictates that once an award is issued, it's either 20, 30, or 60 days from the date two people sign that award and submit it.
Okay.
In the event that a carrier goes insolvent, like the one I've had with your firm, that can be extended a little bit until FIGA is able to take over after the liquidation. But if a carrier is solvent, then they have to pay that award within the time frame outlined in the policy, and that's typically 20, 30, or 60 days.
Okay. Okay. Rain, we have more questions. We got about 10 minutes, 13 minutes to go, I think, right, guys?
Yep, a couple of more. Some of these you may have already answered, but it's just to be clear with the questions that are coming in. One of them is, what is the procedure for pursuing these claims short of a lawsuit?
The appraisal provision itself is by far and away. I represent a lot of lawyers that don't file suit on their own claim. They simply demand appraisal. They name me as their appraiser. Number one, it's much quicker. It's much more efficient. It's much less expensive. And in my opinion, you get a more fair outcome.
All right, another question that came in that I hope you guys can answer. They're talking about a broker and an agency. And it's saying, what role does the broker / agent have in paying with the claim from the insurer?
Very little, if any. It's a fallacy to think that a broker, in the old days, the agent had a lot of pull. The broker had a lot of pull. Today, I represent those same agents and those same brokers trying to get their own claims paid.
Okay.
All right, here's another question. Admitted carrier versus not in the state of Florida, not covered by Florida fund. What happens with claim if out-of-state carrier goes bankrupt or delays payment if settled?
Well, if it's not a participant in the Florida Insurance Guarantee Association and it becomes insolvent, it's really bad. I don't know of any other recovery.
That's something to discuss with your agent.
Yeah, I would be very, very hesitant unless it's an A++ rated company to insure with any carrier that's not admitted in the state of Florida.
Okay.
Richard, this was a question I think that was given to you about if you can give us an update on what's going on with FIGA this month. Do you have any updates?
I don't, not with FIGA. I know that, you know, we talked about it, or we will talk about it. There's going to be a lot of changes in the reserve rules for condominiums due to the Surfside disaster, which doesn't really relate to the topic we're talking about today. But I've also seen where the president of the Senate the Florida Senate has said that because of the major 25 to 40% increases in insurance premiums this year, he's saying we need legislation to rein in these insurance premium increases because, you know, associations, you know, they're already high. Now they're going to pay any more. I don't know, you know, how they're going to do that, but I think that's on the radar as well to try to give some relief to homeowners. But everything you give relief to the homeowners, the insurance company is going to want their something on their side of the ledger too. So a lot of times, in my experience, these reforms don't really reform anything. Maybe George or John have some comments on that.
I agree wholeheartedly. I actually, ironically, represent the state representative that is on those committees, and they didn't even pay him. I also represented a local sitting judge before he retired. They wouldn't pay him, even though he's a sitting judge. So it doesn't matter who you are, they're simply not going to pay you unless you get help.
Yeah, but I know there's a lot of laws in my industry that they're like, where did this law come from? And when you burrow down and find out, you pissed off a legislator or his mom that lived in the condo. And it's like, oh yeah, well, we're going to change the law. And that's where we get some condo laws that are really obscure because one or two people got pissed off, and pardon my language, and they had the ability to change the law. And I could give you numerous examples. So you don't want to make them mad.
That's exactly the two examples I gave you. I mean, it's just true. You don't want to make them mad.
Right.
Yeah.
Right.
All right, I think this is the last question I have unless somebody types in something else. This was just asking the question, would Keys consider accepting a contract where the fee/percentage is taken only out of the amount that is above what the insurance company would pay out anyways?
Yes, we do. We do it every day.
Okay.
We're here to
well,
help. Yeah, we're here to help. We're not here to be a debt and to an association. We developed our reputation by performing, and generally we do that without exception.
Okay. Well, do either of you have any final words to our? Looks like we got over 60 people on this, so that's a good turnout. Any final words?
Just if anybody has any questions, you can reach out to us, and we're, you know, they think anything after this presentation, we're here to answer those questions for them.
We're honored also that you guys asked us to participate, and best to everyone.
Thank you.
Okay. Well, I want to thank you personally because, again, for years I've not really had a good understanding of this. Our firm has a whole division that works in this area, but that's not my particular area. So this helps me, at least on a general level, be able to talk to my clients. And it's been very informative, and I appreciate you your time today.
Our pleasure so much. Thank you.
Okay.
All right, thank you everybody for your attendance, and we look forward to seeing y'all next month.
Bye-bye.
Bye
Bye-bye.
now.
Thank you.